Hey, everybody. Hope you guys are doing well. Our next little piece of government we're going to study is the Supreme Court. Now, that's really important for you guys as you make your bills, looking at people's rights and the Constitution, making sure that your bill is not violating different parts of the Constitution. We've talked a little about Congress already a little bit. We've talked about presidency a little bit. We're going to get more into that later on if we need to. But I want to use our online virtual days to examine the Supreme Court, the Bill of Rights, and how that whole process actually works. So, starting off here, our Supreme Court has one job, and that one job is to interpret the Constitution. Their job is to look at the Constitution and figure, okay, is this law or this judicial or this presidential action, going to be a constitutional one? And they have the final say on if an action is actually constitutional or not constitutional. And they get to interpret the Constitution how they feel is right. Each one of the justices will be interpreting the Constitution a little bit different. Right now, we have our 9 justices on here, well, 8 justices. You had the redder ones here are more the conservative justices. Anthony Kennedy, who had retired earlier this year, is off the court now. He was replaced by Brett Kavanaugh, who was much farther to the right than he was. Ruth Bader Ginsburg, may she rest in peace, is off the court after she died 2 weeks ago. And now we'll see if Amy Coney Barrett is going to be was appointed by the president and is waiting to be approved by the Senate. If she's approved by the Senate, she's going to shift the court much more to a conservative side than it was before. There'll now be 6 more conservative justices: Roberts, Alito, Gorsuch, Kavanaugh, Clarence, and possibly Coney Barrett, and 3 more liberal justices: Kagan, Breyer, Sotomayor. Each of these were appointed by Obama. Okay. Now, the justices are the members of the Supreme Court. They're not called judges. I once asked one of our Wisconsin Supreme Court justices why they were called justices, and she explained to me that judges decide guilt or innocent, or they assign punishment, like a sentencing. The justice's only job is to interpret the law and nothing else. And so that's why they're called a justice versus a judge. Now, there's absolutely zero requirement to be a Supreme Court justice. If President Trump wanted to, he could appoint me to the Supreme Court. I doubt he would, but you know what I'm saying, okay? Typically, a Supreme Court justice has a long history of law, of teaching law potentially, of being a judge at a lower court potentially, and he has a lot of knowledge. These are very, very smart people who have gone through a lot of schooling, typically have gone to Harvard or Yale most of the time. Once again, they're appointed by the president, approved by the Senate. There's a long process for the Senate. Right now, Amy Coney Barrett is going to go through a judicial hearing where she'll go through a small committee hearing first and be grilled by a bunch of the senators. Then they'll put up for a vote on the actual floor of the Senate, and the Senate has to approve her or she will not take office. The term is life, again, until you retire or if you die in office or unless you're impeached. There are 9 justices on the court. There have been 9 justices since the 1800s. There's a law that actually says there'll be 9 justices on the court. Franklin Delano Roosevelt tried changing this in the 30s to get more justice on the court, but this law was struck down. Basically, they want to make sure it stays at 9, number 1, so it's an odd number, so that the court never has a tie. The other part of it is that they don't want to add more justices because then a president could add a whole bunch of justices and have a little advantage while they're in charge. The Chief Justice, kind of leader of the court, is John G. Roberts Jr., appointed by George W. Bush. And his job is kind of run the court and make sure that he's kind of the leader, makes sure he leads the deliberation and decision-making discussion in the courts. Now, everyone wants to know why they have a lifelong term. Well, lifelong term is there because they don't have to run for re-election. They don't need to change their opinion. They don't need to, change what they say to stay in office. A lot of times politicians may shift their positions. They can keep their same decision, keep their same beliefs, and not worry about losing their job based on how they interpret the court cases. And like I said, that job is literally just interpret the laws, interpret the Constitution, make sure that the laws are correct, that the laws made by Congress or actions by the president are not violating that Constitution. Now, their work year is only part of the year. They usually start around October, so they actually start about right now in the fall when we're recording this during the first quarter. And then they'll hear cases through April. And after they hear the cases in April, then they'll sit down and deliberate the cases. They'll discuss them. They'll research them. Typically, a Supreme Court case doesn't last very long, lasts about a half hour or so for each side of the case, the plaintiffs and the defense to argue their point of view, but then the justices sit down with their clerks and they go through mounds of paper and research and documents to come to a decision. Now, the job of Supreme Court justice was very ambiguous. It kind of wasn't really understood until the case of Marbury v. Madison in 1803. And this case of Marbury v. Madison happened in that it was a case where John Adams had appointed a bunch of people late at night right before he left office. And when the new president, Thomas Jefferson, came in, he ordered his Secretary of State, James Madison, not to do it. And this guy, Stephen Marbury, was like, I want my job. And he didn't get his job. And so he claimed that the Constitution was being violated. They decided that no, it wasn't being violated, and that the court has the right to interpret the Constitution. So it basically creates the idea of judicial review. Judicial review is the idea that the Supreme Court has that power to review cases and overrule laws by Congress and the president. It's part of our checks and balances we talked about in class, and that it makes sure that the laws being passed, the actions being done, are correct by the people and that they're the right things that are going on. And obviously, the Supreme Court here has a very final say. So it kind of gives them a lot of power because they have the final say in a lot of these challenges, and what they say goes. There's nobody above them that can change it. The only way something can change is if the court will make a future court makes a different decision. For example, abortion was deemed legal in Roe v. Wade in 1972. Courts since then have used that decision to make their future rulings, but a future court could overturn Roe v. Wade and make abortion illegal technically. Now, there's four different things we have to know here, and please write these things down, okay? About how Supreme Court justices make their decisions, okay? The first one's something called judicial activism. Judicial activism is a more liberal interpretation of the Constitution that says that courts can play a role in politics. This comes a lot of times in civil rights. We saw this in the 50s in the civil rights movement. We may have seen this in the gay marriage movement, possibly the abortion movement as well here, in that a justice is more willing to overturn a previous case because of current politics that are happening and to change how politics are working that way. The other option outside of activism is called judicial restraint. And restraint is a less willing to overturn the case and use something called precedent. Precedent is how the previous cases were decided. Typically, a previous decision is used to make the future decision. So a judicial restraint is going to be keeping the previous decisions, keeping things more the same, and not changing their ideas based off politics. The other thing we have to look at is how the justices read the Constitution. There is something called a strict construction or a strict interpretation of the Constitution. This means that the justices essentially read the text word for word. And so it's kind of a what you see, what you get kind of thing on here, okay? For example, in the Second Amendment, it says the right of people to keep and bear arms shall not be infringed. So a strict constructionist will say, hey, it's written there. You can't interpret that kind of stuff. But before that, it says a well-regulated militia being necessary to the security of a nation, of a state, excuse me. And so they're not going to take that first part into account. They're going to say, hey, right to bear arms is in there, so right to bear arms. Somebody who interprets this more may say, well, you meant that, but now it kind of means this instead. They also do what's called an originalist. So they use the original meaning of the Constitution and the original text. So they don't really interpret it or kind of apply it to modern day kind of things. A more loose construction means you interpret it and apply it to more modern day situations. Now, with the Second Amendment again, they may say, well, in 1787, they didn't have semi-automatic weapons. They didn't have, assault type rifles. They didn't have, they had muskets. It's a different kind of situation now. And that's kind of where they're going to be applying that more modern day situations to this. They try to think of what was the framers' intent. Basically, what do these guys want to do, and then apply it to our today's situation. They talk about freedom of speech all the time. They may say, well, freedom of speech back then meant newspapers. Now we have the internet. So how do we have to change our interpretation of freedom of speech that way? What we're going to have you guys do is, as you finish watching this little video here, we're going to look at another video and kind of see how it comes into. All right. Obviously, judicial opinion plays a big role in stuff here. And we kind of see how the nominations go here with everything. And now there's 3 more liberal justices and 6, potentially 5 now, potentially six more conservative justices. We may see a more constructive, strict construction of the Constitution. Typically, a more right-leaning judge or justice will have a more strict construction, use more judicial restraint, whereas a more liberal justice will have more of that loose construction of the Constitution applied to more situations. And we'll also see a lot more activism on the left side. So we could see a big switch in the court here as going forward. Now, watch this video. Thank you for that. I'd like you guys to check our other puzzle video that's posted underneath the Constitution. Watch the Obergefell v. Hodges case and answer the questions about it on Google Classroom. Thank you very much, ladies and gentlemen, for your attention and your time. I greatly appreciate it, and I'll see y'all in class.